our Vice Chair, Mr. Weiss, and our member, Mr. Zine. So with that, let's go ahead and take the first one has been asked to continue till the 26th of March without objection. We will go ahead and do that. Next item, please.
Item 2 is a report from the Chief Legislative Analyst relative to the State of California's suit against the U.S. Environmental Protection Agency. We have Mr. Charles Modica from our office.
Hi, Charles.
Afternoon. This item pertains to Resolution Gruhl-Perry-Smith, which is in support of the State of California's lawsuit against the U.S. Environmental Protection Agency's decision to block California's proposed emission standards for cars and light trucks. The Federal Clean Air Act gives California the right to set its own vehicle emission standards that are more stringent than federal regulations. In order for this to happen, the state must submit a waiver request to the EPA. The EPA then has the option to either grant the waiver request or propose changes to that waiver request.
I think that's a good thing.
I think we should support it.
All right.
If you're good. All right.
You good?
Gotta breathe that clean air.
All right. Spoken like a true motorcyclist. All right. Let's go ahead and move approval without objection. Next item.
Item number 3 is a report from the Chief Legislative Analyst relative to the city's position on 3 or 4 bills having to do with unemployment insurance, and we have Ms. Annie Danino from our office.
Good afternoon.
Oh,
We also, I believe, there's a representative of the City Attorney's Office who wants to speak on this.
okay. Like to come forward as well?
There's also the interim director of the Commission on the Status of Women.
Great.
as well.
And everybody's for this, right?
Yes.
Give us a brief overview.
HR 4015, 4014, and 4016 are pieces of federal legislation that offer economic protections to victims of domestic violence. 4015 prohibits employers and insurance companies from basing hiring or coverage decisions on an individual's history of abuse. 4015 provides job protections for domestic violence victims, including time off for medical attention, the ability to seek legal assistance, or participation in court proceedings that are a result of domestic abuse. And 4016 provides unemployment insurance to those who are separated from their employment as a result of domestic violence. And currently, the status of the legislation is they're all in the committee process.
They're in Judiciary?
Within the House.
The House?
Yeah.
House Judiciary Committee or?
The House. They all actually are in various committee
Okay.
process. I could,
Some of the banking ones and stuff?
yeah, like
For insurance.
4014 is
Okay.
in Commerce and Trade.
Okay. Well, these were introduced by Ms. Roybal Allard, whose district we sit in right now. They were seconded by Mr. Weiss. Would you like to add anything from the city attorney perspective?
Well, I'll just say I'm actually here as the head of the Legislative Issues Committee of the DV Task Force.
Right.
I actually worked on some of the legislation that we have in California from which this comes, and
Excellent.
she is Lucille Roybal.
Would you say your name for the record, too?
Oh, Eve Sheedy.
Thank you.
Sorry. Domestic Violence Legislative and Policy Advisor for Los Angeles City Attorney's Office. Congresswoman Allard has presented these bills as in one form or another since 1996,
Right.
and this year the strategy was to separate them out in the hopes that they would actually be able to move forward, although now they're being held in committee and due to other political issues may or may not move forward. But they are really, really important protections, some of which we already have in California, some of which we don't. But the viability, helping to support working victims of domestic violence really enables these victims to not have to choose between their economic viability and being safe. So they're really critical provisions, and I would ask that you support them.
We had 2 of us with the motion, which is
Oh.
a majority, and I know Mr. Zine has been a good worker on domestic violence issues as well. So, any questions?
I'm actually shocked that a person would get terminated if they're a victim of domestic violence. I mean, to see this legislation that an employer would terminate an individual who's going through stalking, sexual assault, domestic violence, dating violence, that an employer would be so ruthless as to terminate an employee that is going through this emotional trauma. I find that, I mean, I support all this, but to think in this day and age that an employer would be that cold and callous to terminate someone who's going through that ordeal. And I served on the Battered Women's Shelter at Haven Hills, so I'm familiar with this domestic violence, and I never even thought about the issue where an employer would be so cold and callous to fire an employee for having gone through that. And there's enough trauma that they have to go through, leave alone worried about the economic support of themselves and their families. So definitely support this. And I commend my two colleagues on the committee for bringing this forward. And I know Congressman Allard has been a strong supporter of rights for everyone. So hopefully, you mentioned this has been going on since the 70s. She's been trying to get something done.
Well, she's introduced it, 1996, thankfully, not
96.
since the 70s, but it's
That's a long
interesting.
time.
The one provision you speak of is the one state law we don't have, but the great city of Los Angeles has a very protective policy for working victims of domestic violence. So we're actually, at least within the city, ahead of the curve. So
Does it go into the other categories? We talk about domestic violence, which is that broad category, but here it talks about dating violence, sexual assault, stalking. Does the city cover all those areas or just domestic violence?
the city's policy deals with domestic violence, but has a fairly broad definition of abuse, which would probably cover, it would certainly cover dating violence and sexual assault.
What about stalking? Because
I believe so. The city's policy, the way it's drafted, is very broad and allows for a fairly broad interpretation. So it's well crafted. Most of the federal legislation now is drafted using those four terms because that is an echo of how the Violence Against Women Act is drafted. It's those four categories. So they're divided. Generally in federal law in this area, those four categories are listed separately. In some state law and within LA, the categories are sometimes collapsed and defined differently.
But now, well, the city has protections, and this is going to seek federal protection, which will obviously cover the United States. Do we have California? Does the state cover the same area?
California state has a few, doesn't have all of these provisions. The state of California has a law that protects domestic violence victims who leave on the unemployment insurance front. If you leave employment because you are a victim of domestic violence, that constitutes good cause under California law, which is a law I drafted. Then there is Labor Code 230 and Labor Code 231, California state law, which protects domestic violence victims if they have to miss work in order to seek protection for themselves or their children for the health, safety, or welfare, and that would include going to court to get a restraining order, having to appear in family court, having to appear in dependency court, or anything like that. And that's part of the legal code section that talks about if you're a subpoenaed witness, which I know you're familiar with. Then there's 230.1, which provides for a greater amount of leave if you have to seek other kinds of resources for domestic violence. If you're seeking medical care, psychological care, or additional kind of services, that protects you in your employment. We don't have a non-discrimination law in California. Senator Kuehl introduced that the last 2 years, and it was not able to move forward in the state legislature. So it remains, although there's a legal argument you can make based on public policy, it's not the express terms of the law of the state of California.
Okay, thank you. And thank you for your hard work on this over the years.
Sure.
Okay. Move approval. Thank you all very much for being here. We'll send that to council. Next,
Item number 4 is continued from December 12. It's a report of the chief legislative analyst relative to transferring the, responsibility for security officers from the Department of Consumer Affairs to the Commission on Peace Officer Standards and Training, also known as POST. We have Anne Marie Sauer from our office. And we also have an amended resolution, which, if your committee agrees with, should be adopted by the committee.
Which item is this, Mr.?
Item number 4.
This is was there a motion on this?
yes, there was. We had this in council. This was a Mr. Parks motion, and we had some folks show up that were from the academies and from our own policing agencies that raised some issues.
So it's about whether private security guards get a different status.
They're right now under Department of
California
Consumer Affairs, but along the lines kind of what we had proposed, I think, a while back,
Okay.
is about professionalizing standards, I believe. And I know Mr. Parks is folks are here as
I
well.
didn't understand what this.
Yeah.
okay,
Well,
that's-
why don't you give us the
It's
presentation?
the licensing, though, transient from Consumer Affairs
To
to
post.
Peace Officer Standard and Training, which licenses police officers in
Correct,
California.
correct.
So it's just the licensing requirement will go to a different agency.
And the training as well, but let's hear a little bit more. We
Right.
can, I'm sure, have
Okay.
it illuminated better than I can.
No, you guys did a great job. Anne-Marie Sauer with the CLA. As it was indicated, you did hear this in December, and then at that time there was discussion. Well, real quick, basically what the resolution provides for is that the training would move from the Bureau of Security and Investigative Services in the Department of Consumer Affairs to the Commission on Posts, which obviously trains sworn peace officers. At that time, there was discussion about the impact it would have on our academies, et cetera, the cost of basically what would happen with the resources. So there were three things that,
Why would it have an impact on academies?
because the concern is that the training, because if it does move from Department of Consumer Affairs, which is sort of basically the different entities can, or the
Right
different.
now, you can be trained at a private institution, but the concern is that if it were regulated under post, you would have to be trained at a public academy?
Right, that
To
it would
a
be at a
certified-
post-certified academy, and that would
Which
obviously,
is one of them, so
Okay.
there was a worry about that.
right, so that was
There are
one of
also
the.
private locations, like Rio Hondo has a training academy.
Right, and-
certified by Post,
Correct.
So it doesn't have to be a police academy.
No, it would be one of the ideas that if it moved, that there are, though, the 39 post-certified academies, and what impact that would have. And obviously, because of the number of security guards in the state, that could ultimately have a big impact, because what some of the testimony was is that the post academies are already, as we know, kind of strapped and, overburdened as it is. So here, if we're asking that this be added, what would that mean? So part of that was that the resources, basically, that are, one of the things is that you all had asked about was that the resources that are currently dedicated to Department of Consumer Affairs for this would be moved to post. So that's part of what's included in, basically, that there would be funding in post to handle this if we make that change. And then the other is that there would be additional sources of funding that would be identified for those academies so that they wouldn't be overburdened, basically, if they take on this responsibility of training the security officers. So that's basically what's changed in this new resolution that's before you. And then the other piece was the number of hours, because right now the security officer training is only 40 hours, whereas the sworn peace officers, it's the minimum of 664 hours. And so you would ask that we look at, basically spelling that out. So that's what's been spelled out here, is there would be a new standard of training. We would ultimately come up with what those hours are, but something between the 40 and the 664 hours.
This is one of, I realize that that's what this committee does, is votes on all these. There ought to be a law, resolutions, which I know we've all done from time to time, although I've done it from time. Others have
We've done it from time to time. Some of us have done time to time to time.
Yeah.
And some have been time, but not us.
So there are two flavors of these sort of, I wish it were a law resolutions. One is, I wish it were a law and someone's already introduced a bill. And the other is just, I'm wishing really hard that there would be a law. And if I keep on wishing, maybe someone will introduce a bill. It's in that category.
It is.
There's no
This is
bill.
because this is to sponsor legislation, and what's happened since we met, basically, our office has worked with Mr. Parks' office and the CalSega, which is sort of the state union that deals with this, and so in the process of all of this, there is a placeholder, basically, that I believe Karen Bass has put in order to meet the legislation deadline.
Right.
So but
Has
it's
there been discussion with the folks who represent the security guards in LA? Because it seems to me,
Yes.
without knowing, that conceivably this could be this could be an expensive proposition for companies to comply with, and it might be wishful thinking to believe that they would all just pony up the extra dough and comply with it. They may cut, it could have a negative impact on people. Has there been a discussion with those people?
Yeah, and the councilman, David Hirsch with Councilman Parks' office. The councilman actually introduced this resolution at the request of SOLA, of the union. In terms of the companies themselves that have to employ the security guards, that's one of the issues that still has not been worked out, but in our discussions going forward will be worked out, at least will be discussed. But right now where we are is Ms. Bass has put into bill form intent language, which basically spells out what we want to do. And then since the bill deadline to introduce bills is the 22nd of February, that's why we're coming back and wanting to get this resolution passed.
That's fine with me.
Mr. Zine?
The cost currently, if someone goes to Rio Hondo, it's out of their pocket unless they're hired by a police agency. Has the cost been discussed? Who's going to pay, the applicant or the company employing the security guard, or has that not been discussed?
These are all issues that will be negotiated once the bill is in print.
And then the other question regarding staffing, moving consumer affairs over to the Peace Officer Standard and Training, there may not be adequate staff at consumer affairs at this time, and the standard for post is much different, and the requirements and the recertification. So if they're just talking about moving inadequate staff, that's not going to help. It'll just clog the system.
Right.
So that has to be worked out, that the appropriate staff to be identified by post and the appropriate funding to do the program. It's just like when this issue about issuing driver's licenses to everyone, and you go to DMV and there's no additional appropriation for personnel. So what you have is lines that are 4 miles long and nobody can get in. If this were to come to fruition, there's a big gap between what is needed and what they're going to have. So if it does happen, I think it's a good idea. I think it brings it more into professional standard with security officers, security guards, and it gives them a different standard that post-license, you can go anywhere in the state, and you're obviously going to receive more compensation, better training. But there's a whole bunch of details.
No, of course.
Yep, that's to be worked out.
And once the lobbyists get a hold of this, and the city lobbyists, hopefully those will all be worked out in a further iteration of the legislation.
Can't move.
All right.
And just one
As
more thing,
amended.
some of those folks may not be able to qualify too. That's the other
Remove the
concern,
previous motion.
because of different standard.
Mr. Zine, Eric Garcia just cut you off. Did you
Just
notice?
move the previous question. He just shut debate off like that. He moved the previous question.
Let's move it.
All right.
Two-thirds vote requirement.
Two-thirds vote required. I think we've got the votes locked up. All right.
Vote absentee.
With that, we will move approval as amended. Thank you very much. Appreciate it. Last item, please.
Item number 5 is a report from the Chief Legislative Analyst relative to two bills which would make some enhancements to the empowerment zone and renewal community provisions in the IRS code. And we have Andrea Galvin from our office, as well as a representative from the CDD.
Cliff
Great.
Weiss, CDD.
Hey, Cliff.
Andrea Galvin, CLA, HR 2578 and S1627, also known as the Empowerment Zone and Renewal Community Enhancement Act of 2007, would amend Internal Revenue Code provisions relating to tax-preferred empowerment zones, rural enterprise communities, and renewal communities to extend the period of designation for such areas through 2015, provide a safe harbor standard for employee residency requirements in the empowerment zone, eliminate certain residency requirements for the empowerment zone employment tax credit, grant authority to expand the boundaries of the empowerment zone, allow carryovers of unused expensing allowances for empowerment zone businesses, allow certain empowerment zone businesses to elect to receive payments in lieu of tax benefits, allow federal guarantees and tax exemptions for enterprise zones and renewal communities, and allow the issuance of tax-exempt rural enterprise community bonds.
Great. Thank you.
I'll move approval of the Garcetti motion.
Thank you. Any questions?
None this time.
You reserve it for later. We have, okay, it's for general public comment. So we'll go ahead and move approval. Thank you very much. Appreciate it. And we have a general public comment. Arnold Sachs, would like to come forward? The renewal communities. We've got, this is the empowerment zone, which is different. The renewal community. And then that was the big controversy, the state one at the Valley.
Good afternoon. Thank you very much, Arnold Sachs. I thought I'd take this opportunity to find out if we could talk about some rules for city council meetings, especially regarding amendments and motions made by at all. And I'm just concerned. when you have an item on the agenda, and the council presents an amendment to that agenda, that means the amendment hasn't been heard in the
We can't do an
hearing.
amendment to the agenda, just to clarify, we can amend items, but we can't amend the agenda. Is that what you meant?
Well, like today.
Right.
You can't amend the agenda, exactly. You can amend items on the agenda. So if a councilman presents an item, an amendment for an item on the agenda, and it hasn't been heard in public hearing, I'm kind of confused about at what opportunity does the public have an opportunity to question or comment on the amendment that is presented by the council or presented to the council. If it hasn't had the opportunity in committee hearing, and it doesn't have the opportunity in council hearing because the item has already been heard, then basically the public has no right to make any comment on the amendment. And let's just say the amendment said pay raise for everybody.
I'll second that motion.
Okay, I'm sure we would have plenty or how about pay cuts for everybody? I'll second that one. So at what point is there a happy medium? Today, it was presented by the chairperson of the today's meeting, council meeting, that substantive amendments had been made that allowed for public comment to be reopened, even though I believe a councilman had said that he would like to have public comment reopened. I believe it was you, I'm not sure, that said, but then they wanted to, it was a matter of order of how you were going to run the meeting. So if you hadn't asked for it, who knows if there would have been public comment allowed?
Well, thank you. Very brief answer from Dion, because there is a standard for that, and then we will ask you to talk to him further. I know sometimes you leave after you ask the questions, but he's here, right here. We can take a couple minutes and you can talk to him about that, but we can't directly respond to it in the committee under the Brown Act for the same reasons, because people didn't know you were going to be asking that, and they didn't have the notice for the exact same reasons, but we'll make sure you get the answers.
Okay. And just briefly, the Brown Act allows public comment in committee, and if that item has not changed substantially between committee and council, public comment is not required. If the item has substantially changed in that interim, then the Brown Act requires that there be public comment. So it's a judgment call as to whether an item has substantially changed from one local body to the next.
There you have it from the expert that we listened to as well. So, thank you very much, Mr. Seth.
No, it doesn't quite get it.
Okay, well,
Because
right
I
here,
mean-
if you want to ask everything else.
I'll talk to you.
The County Board of Supervisors has green sheet for changes and amendments. They make amendments to their motion.
Yeah. And then they continue.
Nice job, the green sheet.
And they can, but no, but then they make oral amendments as well.